Hello viewers, welcome to Courts Today by LiveLaw. Let us get to today's top headlines. Justice Manmohan has taken oath as a Supreme Court judge today. The Delhi High Court has granted interim bail to Unnao Rape Case convict Kuldeep Singh Sengar on medical grounds. In the Delhi air pollution matter, the Supreme Court has today allowed GRAP Stage 4 restrictions to be relaxed up to GRAP Stage 2. In a false cow slaughter case, a Gujarat court has acquitted 2 persons and has ordered criminal action against police officers. A plea has been filed in the Supreme Court to stay CLAT PG-2025 results, alleging errors in the provisional answer key. The Supreme Court has directed all states to penalize government officers who cause delay in filing of appeals. And Supreme Court has rejected AIA-DMK MLA's plea against Tamil Nadu Speaker for defamation and said that there is no defamation in saying that MLAs were ready to switch parties. In a medical negligence case, the Supreme Court has dismissed the appeal of a doctor who was held liable for doing surgery on wrong leg of the patient. I am your host Urvashi Chauhan with your daily roundup of legal updates from across the country. Before moving ahead, LiveLaw Academy is offering a value-packed opportunity for aspiring judges. The Judicial Service Examinations Preparation Course. This 18-month comprehensive online course is designed to help you prepare for your judiciary exams. Classes are conducted by expert faculty, including retired judges. You would learn from actual case studies and other easy-to-follow study materials. And all of this comes at a very affordable fee. If you are gearing up for the judiciary exams, this is a must-check opportunity. Enroll today and get 25% scholarship. You can check all details at www.livelawacademy.com. Link is also provided in the description. Newly elevated Judge Justice Manmohan took oath as a judge of the Supreme Court today. The oath was administered by Chief Justice of India Sanjeev Khanna in the presence of all judges. Earlier this week, the central government had notified Justice Manmohan's appointment as a Supreme Court judge. He is the son of Jagmohan Malhotra, the former governor of Jammu and Kashmir and former lieutenant governor of Delhi as well. Justice Manmohan was designated as a senior advocate in the year 2003 and was appointed as additional judge of Delhi High Court in 2008 and was made a permanent judge in the year 2009. Further, he took charge as the Chief Justice of Delhi High Court last year. The Delhi High Court has today granted 2 weeks of interim bail on medical grounds to the expelled BJP MLA Kuldeep Singh Sengar, who was convicted and sentenced to life imprisonment in the Unnao Rape Case. A division bench of Justices Pratibha M. Singh and Amit Sharma, noting his health concerns, directed him to seek admission at AIIMS tomorrow. The court ordered his medical examination by a medical board and directed AIIMS to submit a report on the same. Though the plea for interim bail was opposed by the survivor victim as well as the CBI, the court said that his medical ailments cannot be ignored. The court has directed to not make any attempt to contact the survivor and to remain in touch with the concerned investigation officer daily. In this case, if you remember, the victim was repeatedly gang raped in 2017 by Sengar and his accomplices when she was a minor. Sengar was convicted for raping her and for murdering her father in connivance with police officers and has been sentenced to life imprisonment. The Apex Court today allowed the Commission for Air Quality Management to reduce the Graded Response Action Plan, that is GRAP Stage 4 restrictions, in Delhi to GRAP Stage 2 as there is a downward trend in the AQI. The court advised the Commission to also consider adding certain measures under GRAP Stage 3. The bench of Justices Abhay S. Oak and Augustine George Massey said that if the air quality index crosses 350, GRAP-III should be imposed, and if it crosses 400, GRAP-IV must be imposed. The court will take up the matter next Thursday for further monitoring. In the next update, a sessions court in Gujarat's Godhra has found 3 state police officials and 2 punch witnesses, one of whom is a Rakshak, for filing a false cow slaughter case against 2 men, accusing them of transporting cattle for the purpose of cow slaughter. The court has ordered filing of a criminal complaint under the Bharatiya Nyaya Sanhita for making a false charge of an offence with the intention to harm or injure someone against them. Acquitting the 2 accused in the July 2020 case under the Gujarat Animal Prevention Act and Animal Cruelty Act, the additional sessions judge Parvez Ahmed Malviya observed that the complaint filed against them was entirely false, which resulted in their wrongful detention for nearly 10 days in judicial custody. The court noted that the wrongly accused persons were also entitled to compensation, and hence they can file proceedings for compensation against the state, the erring police officials, and the punch witnesses. In addition to the criminal complaint, the court has also ordered the Superintendent of Police to launch departmental proceedings against the 2 assistant head constables and 1 police sub-inspector. The Common Law Admission Test PG exam generally conducted for admissions to LLM programs in the national law universities and recruitment for PSU legal positions took place last Sunday. As usual, students have come forward highlighting significant lapses in the examination process. Challenging the provisional answer key released for the exam, a writ petition has now been filed in the Supreme Court. The petitioners who appeared allege various lapses in the conduct of the exam held by the National Consortium of National Law Universities. They allege that the provisional answer key released on 2nd December has various errors and as many as 12 questions have been given wrong answers. They state that only a day's time was given to the candidates to raise objections to the provisional answer key, and the online portal was closed on 3rd December at 4 p.m. The final answer key is scheduled to be published on 9th December and the results are to be announced on 10th December. In this regard, the petitioners seek a stay of the publication of results and the counselling for admissions on that basis. They also take objection to the condition that a candidate had to pay 12,000 to raise objections to the 12 answers. Because even after charging an exorbitant fees of 4,000 rupees towards the examination fees, the consortium accepted objections only upon payment of 1,000 rupees per objection. The petitioners also claim that they were not given equal treatment as they were given the sealed envelope having QB and OMR response sheet only after 2 p.m. though it was supposed to be given to the candidates at 1:50 p.m. The petitioners contend that their fundamental rights under Articles 14 and 21A, that is, right to education, have been violated due to the improper conduct of the exam. A Supreme Court bench of Justices J.B. Pardewala and R. Madhavan heard a special leave petition filed by the state of Madhya Pradesh. The petition challenged the High Court's decision to not allow a delay of 5 years in filing second appeal in a case. The case involves a land dispute where the trial court ruled in favor of a private individual, rejecting the government's claim on that land. The first appellate court's judgment was delivered in 2014, but the government advocate informed the collector about it only a year later. The collector took another 3 months to inform the principal secretary. The law department then delayed the approval for filing an appeal by 3 years, granting it in 2018, and finally the state filed the second appeal in 2019, resulting in a delay of over 5 years. This case highlights the typical delays often seen in government offices. The court refused to entertain the petition as the delay was not sufficiently explained. A cost of 1 lakh rupees was also imposed with a stern warning to the states against filing unnecessary appeals. Significantly, the bench has directed all states to fix liability on government officers who cause delay in filing of appeals or cases on behalf of the government and thereby cause loss to the public exchequer. The court noted that in many cases, appeals are delayed because decisions are not communicated to higher authorities on time. As a result, appeals are often dismissed due to the delay, even though the matter is of significant value. Defamation cases involving political leaders have become an ongoing saga, with heated debates and high-profile cases making headlines. These cases often arise from strong political statements, public comments, or social media posts leading to accusations and counter-accusations. In one such case, the Supreme Court today denied to entertain a defamation case against Tamil Nadu Legislative Assembly Speaker M. Upto. AIADMK's Babu Murugavel had filed the case, alleging that Upto, while participating in a book release function in 2023, said that after demise of former Tamil Nadu Chief Minister J. Jayalalitha, AIADMK was struggling with an in-flight, and around 40 MLAs of the party were willing to shift their loyalty and join DMK. Claiming that the speech defamed the party and its MLAs, Murugavel filed a complaint under IPC. The Speaker Upto, on the other hand, approached the High Court for quashing this complaint, contending that Murugavel had no locus to maintain the complaint since the alleged imputation was not against him, nor was he authorized by the party. The High Court agreed with this and quashed the case. Muruga will now approach the Supreme Court against the quashing order. But a bench of Justices Hrishikesh Roy and S.V.N. Bhatti of the Supreme Court has dismissed it. It said that the question as to whether the complainant is an aggrieved person has to be determined on a case-to-case basis. But in this case, what was to be determined was whether the alleged statements were defamatory. The bench said that during political discussions, it is common for someone to say that many members from one party will join another. The court questioned how this could be considered defamation, pointing out that such shifts in political alliances are natural in a democratic setup. Justice Roy noted that the Anti-Defection Act exists because the Indian political system recognizes and deals with such changes. He emphasized that it should not be seen as something unusual, as the law is specifically designed to address this situation. And now let me tell you, the Supreme Court has dismissed an appeal filed by a doctor challenging an order of the National Consumer Disputes Redressal Commission, holding him liable for medical negligence because he conducted the surgery on the wrong foot of the patient. A bench comprising Justices P.S. Narasimha and Manoj Mishra dismissed the appeal filed by the doctor who worked as an orthopedic surgeon at the Fortis Hospital in 2016. The consumer complaint was based on the allegation that the surgery was performed on the patient's left leg instead of his injured right leg. In June 2024, the NCDRC awarded the patient a total compensation of 1 crore 10 lakhs. Out of which the hospital was asked to pay 90 lakhs and the two doctors, including the surgeon, were to pay 10 lakh rupees each. The surgeon claimed that during the operation an injury was found in the patient's left leg and the patient gave oral consent for surgical treatment. However, the NCDRC found gross medical negligence as all pre-surgery tests and consent was specifically for the right leg. For more information on the cases that I discussed, you can visit our website at www.livelaw.in. Your support means the world to us. So please do not forget to like, share and subscribe to our channel. You can support us by clicking the thanks button below our videos or by becoming a member for just 89 rupees per month.